Thank you all for joining us in the disorienting world that we're living in now. This is how we do everything. And welcome to the Drexel Law Review Symposium, Impactful Interactions, Autism Spectrum Disorder in the Legal System. Autism spectrum disorder as a legal issue has been a significantly under-addressed area. And we are very proud to host this event. So excited that the Drexel Law Review decided to take this important project on, and so pleased that we've had an opportunity to partner with folks from the A.J. Drexel Autism Institute, which is the first research organization built around a public health science approach to understanding and addressing the challenges of autism spectrum disorders. I especially want to thank, of course, Whitney, and particularly the Drexel Law Review executive editor, Evan Polgren, and Lindsay Shea from the Institute. People have put a lot of work in. Evan has put so much work in to make this event happen. Events like this are not self-implementing. They take labor and attention. They're nerve-wracking. And I'm so appreciative that you guys put so much in. And I want to also thank all the other people who worked so hard to put this together. And similarly, in every different domain, an event like this requires time and energy from everyone thinking about design and organization, bringing people together. And I want to thank all the people on the Law Review, as well as all the law school faculty and staff who've been investing so much time and energy into this. And I'll finish the thank yous in a second, but I really want to thank all the panelists and participants. That's what makes a program like this run. It's also an opportunity, to welcome some number of you to Klein School of Law. Some of you may not have as much familiarity with our young institution. We're only 14 and a half years old, but we are nothing if not a passionate law school. We are passionate about hands-on education. We're passionate about our community, our legal community, and beyond that here in Philadelphia. And we're particularly passionate about using law as a tool for social action. Whether it's through our Center for Law Policy and Social Action, our clinics, our intense pro bono commitment, this symposium is a perfect fit because it marries questions of law to questions of how to change the world for the better in a space that requires attention and a space that requires people to move beyond their comfort zone to transform lives and communities. I will admit, I don't know if it's an admission, it is a truth, that this conference, this topic is a particular passion for me. Over 20 years ago, I began my work as an advocate for people with disabilities in Alabama, in the school setting largely, but also involving litigation, involving devices, working with communities. In addition, like so many people, I lived in a world of people with differing abilities, with a mom who was hearing impaired and an incredibly misunderstood, but also incredibly accomplished sister on the autism spectrum. So this event has real resonance and meaning for me. And I'm very moved that the Law Review decided to go ahead with this event. It is important. But more broadly, this is an important juncture for disability law and particularly for autism and the law. There has been, over these last 20 plus years, a significant increase in the scientific and social awareness of autism, reflected, I think, very positively, for example, or maybe made possible by the A.J. Drexel Autism Institute. At the same time, the American legal system has been slow to recognize and to respond to the institutional barriers that have been created for people with autism. I think about one example of some of the discomfort is in the form of the reluctance of the United States to ratify the Convention on the rights of people with disabilities. So this symposium's goal is to prompt a robust conversation on the barriers that arise for people with ASD, autism spectrum disorder, and particularly the barriers that arise when they engage with the legal system, and to talk about possible ways of thinking about meaningful change. And more particularly, as part of this is designed to be a wake-up call for legal practitioners, for the lawyers. As a new generation of legal professionals, as new generations of legal professionals enter the field, it's incredibly important that we learn from the mistakes of the past, that we acknowledge the historically inadequate support autistic people have received from society, and to take steps in the right direction. This is a moment more broadly in our society of the recognition of our failures, but the willingness to sort of embrace the challenge ahead and to be honest about what it takes to move forward. So I want to stop for a second and sort of talk a little bit about what autism spectrum disorder is, for those of you who may have fuzzy ideas on it. It is a broad range of conditions characterized by challenges that individuals have with social skills, with repetitive behaviors, with speech, with nonverbal communication. And so we open with that because that's so typical that you'll open with sort of the challenge element. But while ASD can present huge challenges, they also do present strengths, whether it's splinter skills, a reliability and dependability that's especially true in employment settings, and attention to detail. And for me, in this very personal way, and in a way I think many people don't appreciate, folks with on the autism spectrum, with autism spectrum disorder, can bring perspectives on questions and issues on art that challenge dominant paradigms. I know that my sister was able to create new space for new possibilities about Gustav Mahler that simply were not available to neurotypical people. Now, autism affects a pretty significant portion of our society. Although this number is sort of under study and under contention, it's something like 1 out of every 50 children or so. The thing about it, as with disabilities generally, is it occurs across all racial, ethnic, and socioeconomic groups. It's a challenge in some ways to look on and see that we have a challenge for society that, notwithstanding the fact that it's shared by everyone, we have so much trouble going forward, sort of addressing. The spectrum characteristic of this variety of character traits makes diagnosis challenging. And there isn't one autism. There are a variety of subtypes which are influenced by all kinds of different factors. Another difficulty in sort of capturing this idea of an essential ASD is that because every person may have different manifestations and different ways that they think and problem solve, people require different support in their lives from the general population, and also different supports as between people with autism. So that makes it a little challenging. And in the little bit of time I have left, I do want to touch on one other thing, and that's the issue of terminology. It's really important to recognize that in the disability community generally, and certainly in the autism community, there are a lot of different voices with different opinions about how to talk about people with a disability, people with autism. And I think if there's anything that I sort of have gained in my work with members of the disability community, is the importance of affirming each person's identity, and they may capture it in different ways. So you may think, I mean, there will be some folks who will want to focus on the notion of the person first, a person with autism or with ASD, rather than an autistic person. But ultimately, this is very much an individual conception, and it's important sort of to engage individuals to figure out their preferences for language. And so I want to note that in part because we're going to see, even within the conversation today, sort of movement around language. And for those who are not sensitive to it, I just want to be aware that choices of language here are both intentional and consequential. And if you're an advocate for people with disabilities, it's something to be sensitive to. There isn't a right answer on it, but I want to flag it because I'm sure over the course of today, this will surface. So in the conference today, we are exploring the place of autism spectrum disorder and people with ASD within three contexts: within the context of criminal law, education, and healthcare. It's worth noting that all three of these contexts are complicated and fraught for society at large. All three are sites of contention, of sites of fractured consensus, and systematic failure. And that's entirely separate from issues of disability or autism. Just think about the incredible debates and the challenges we're facing in the area of criminal law. And immediately we think of the agonizing videos that we're seeing of police shooting Black people. And yet this problem of policing and violence goes beyond into communities of disability. So that earlier this month, a 13-year-old boy, Lyndon Cameron in Salt Lake City, was shot something like 10 times by the police when he had a mental health breakdown. And we have to ask questions about not just what is race in our society, but what is policing in our society, such that the way that we are handling this health crisis of a person with a disability is through police at all, and then through guns. And it touches in other areas, in education, the underfunding, the racial divides, the class divides, the inequality of education has effects on people with autism. And we're going to talk about that today. And obviously, our healthcare system in this country has gaps and holes and tears. And while we know this generally, today we're going to have an opportunity to look at it with a particular focus on autism. So today, what I hope is that this is a great opportunity. It's an opportunity to focus on people with ASD and their relationship to these three troubled domains: the criminal law, the healthcare system, the education system. I think this will be really educational in the specific about people with autism, but also I think it's going to expose broader problems with these domains. I think we're going to learn specifics and we're going to learn more. But my biggest hope today, and why I'm so excited that the Drexel Law Review is putting this program on, is that by exploring solutions to these problems with respect to people with autism, we may not only give ideas to the many practitioners and scholars who are participating today, but we may gain broader insights into solving these massive national social problems as well. So again, I want to thank all the people who've made this possible. I want to really share appreciation to Evan and all the panelists. And I wish everyone good luck today. I hope that you find knowledge that helps change your world a little tick, a little bit. At this moment in history, and it's impossible to divorce ourselves from this moment in history, I do think all of us feel a little helpless, like there's a big movement and we're so small. But what we can do and what we must do as lawyers, as citizens, as people socially engaged, is to take steps just like what we're doing today, to make a small gain, learn a small thing, apply a small insight. And if we do this collectively every day, that's how we're going to make the world better for people with autism, for all people. And I hope all of us are able to do just that over the course of this day. Welcome.
So I'm Emily Zimmerman, and welcome to everybody who is here. I'm a professor at the Klein School of Law, and I'm also the director of our criminal law program. And so I'll be moderating our first panel, which addresses ASD in the criminal justice system. And we have three wonderful panelists, and I will be introducing them to you very briefly in just a minute. And first, before we do that, I just want to echo Dean Filler's appreciation for Evan Polgrain, who is the symposium editor of the Law Review. Evan has done an exceptional job putting this symposium together. So thank you so much to Evan and to all of the other members of the Law Review and to everybody else who did such a phenomenal job in organizing this symposium. And so now I'm very pleased to be able to introduce our panelists for our first panel this morning. And you can read more about them in the program for the symposium, but I'll just give you an incredibly short introduction to each of them. So our first speaker will be Dianah Msipa, who is a program officer in the Disability Rights Unit of the Center for Human Rights at the University of Pretoria. And then our second speaker will be Sam Crane, who is the legal director of ASAN, the Autistic Self-Advocacy Network. And then our third speaker will be Dr. Colleen Berryessa, who is an assistant professor in the School of Criminal Justice at Rutgers University. So Dianah, the screen is yours.
Thank you so much to you for the invitation and for the introduction as well that you've given me. In the 15 minutes that have been allocated to me, I'm just going to speak to you from a topic. Bear with me, it's a bit long-winded, but I'll read it out. It's Kawadi Mshweshwe versus and others versus the DPP and others, a missed opportunity to assert the right to legal capacity and the right to access to justice of persons with intellectual and psychosocial disabilities in Lesotho. So that's a long title, but basically in the next 15 minutes, I'm going to be speaking about a court decision from Lesotho. Lesotho is a small Southern African country. And the decision, I'm going to be focusing mainly on the analysis, the court's analysis of the issues involved. And my main argument is that though the court arrived at the right decision, the court's analysis and its articulation of the rights at stake was wanting. So therefore, the court missed a valuable opportunity to assert both the right to legal capacity and the right to access to justice for persons with intellectual and psychosocial disabilities in Lesotho. I will be focusing mainly on three arguments. The first is that the court did not sufficiently address the right to legal capacity. The second is that the court did not address the right to access to justice at all. And the third and final argument is that the court did not address the issue of accommodations for persons with intellectual and psychosocial disabilities in the criminal justice system in Lesotho. So just by way of background, I'll tell you a little bit more about the Kawadi Mshweshwe and others v. DPP and others case. In 2015, the Constitutional Division of the High Court of Lesotho delivered a landmark decision, I beg your pardon. So in this case, the applicant, named Kawadi Mshweshwe, is an adult man with intellectual disability. So in August 2015, his mother asked him to deliver some cash to a fellow villager. So on his way to make the delivery, he passed by the accused person's house and she invited him into her house and offered him a traditional food known as soft porridge for him to eat. And when he had finished eating the porridge, the accused person instructed the applicant to sit on her bed and she started to undress him. Despite the applicant indicating that he did not want to have sexual intercourse with her, the accused forced the applicant to have sexual intercourse. So the applicant reported the matter to the police thereafter, who carried out an investigation and subsequently referred the matter to court for prosecution. At court, the public prosecutor declined to prosecute on the basis that the applicant was not competent to testify due to his intellectual disability. And in reaching this decision, the prosecutor relied on Section 219 of the Lesotho Criminal Procedure and Evidence Act. So in short, basically this particular section states that persons with intellectual and psychosocial disabilities are not competent to testify in court. I think that it's worth me reading out Section 219 so that you just get a sense of how discriminatory it is. Section 219 reads as follows, and I quote, "No person appearing or proved to be afflicted with idiocy, lunacy, or inability, or laboring under any imbecility of mind arising from intoxication or otherwise, whereby he is deprived of the proper use of reason, shall be competent to give evidence while so afflicted or disabled." And that particular Section 219 has been used to declare persons with intellectual and psychosocial disabilities not competent to testify in court. So as a result, the applicant's case could not move forward without his testimony. After that, the applicant, along with two disabled people's organizations, namely the Lesotho National Federation of Organizations of the Disabled and the Lesotho Society of Mentally Handicapped Persons, Parents, and Families, responded by instituting proceedings in the Constitutional Division of the High Court of Lesotho, challenging the constitutionality of Section 219 of the Criminal Procedure and Evidence Act. The court ruled in their favor and declared that Section 219 is inconsistent with the right to equality before the law and the right to freedom from discrimination, which are both enshrined in the Constitution of Lesotho. Consequently, the court declared Section 219 null and void and went on to order a fresh trial, or what they called trial de novo. So in its judgment, the court raised concerns about two very specific issues. The first is the language, the derogatory language that is used in Section 219. And it also raised concerns about the negative effects of Section 219. Specifically, the court stated that the section is, and I quote, "totally inconsistent with the rationale of the Constitution of Lesotho because of the language that is used in it." And the court went on to state that persons with disabilities, and I quote, "deserve all protection and equality under the law." And that even if the insolent or disrespectful words are removed from Section 219, the negative effect to the disabled remains poignant, and this is quite obnoxious, close quotes. So what I am arguing is that though the court arrived at the right decision, and the court was right to raise concerns about the language as well as the effect of Section 219. The court's analysis could have been stronger. It was inadequate for three reasons. The first is that the court did not sufficiently articulate the right to legal capacity. So though the court identified that Section 219 was inconsistent with the right to equality before the law, it did not go as far as articulating it encompasses both the capacity to hold rights and the capacity to exercise those rights. So the capacity to exercise those rights is obviously the most contentious part of the right. No one has a problem with a person with intellectual disability being a holder of a right. But sometimes people do raise objections to persons with intellectual disabilities exercising certain rights such as testifying in court. So by not addressing the right to legal capacity, my argument is that the court missed an opportunity to assert that persons with intellectual and psychosocial disabilities do have a right to legal capacity as stated in Article 12.1 of the Convention on the Rights of Persons with Disabilities, which Lesotho has already ratified. The second reason is that the court did not articulate the right to access to justice at all, which is also affected by Section 219. So in the law of evidence, the concept of competence to testify relates to the ability or the capacity of a person to give evidence in court proceedings. Only who are competent to give evidence may testify in court. So a finding of incompetence means that the witness will not be permitted to testify, and this may in turn have a negative impact on the outcome of the case. So for instance, in sexual assault or rape cases, such as Kuadi's case that we're looking at now, the evidence of the complainant is of utmost importance for two reasons. Firstly, the sexual act constituting the offense usually takes place in private, with no other witnesses to the crime. And secondly, the complainant is the only person who can say whether or not they consented to the sexual act. So a finding of testimonial incompetence is therefore likely to have an impact on the outcome of the case. So the issue of testimonial competence is therefore very much about access, the right to access justice. And by not articulating this fact, the court missed an opportunity to assert that persons with intellectual and psychosocial disabilities have the right to access justice on an equal basis with others. The third and final argument that I will make is that the court did not address the issue of providing accommodations in court. So the effect of the court's decision, which is welcome, is that there is now no legal impediment to persons with intellectual and psychosocial disabilities in Lesotho testifying in court. So the court, so in that case, the court was right to remove that legal impediment that had been there through Section 219. So though the court went on to order a trial de novo in Kuadi Moshweshwe's case, the court neglected to address the very real fact that persons with intellectual disabilities will face barriers. Even if they're not legal barriers, they will face some other barriers when they are participating in court, either as witnesses or accused persons. One barrier that comes to mind is a communication barrier. So court proceedings are very, very verbal. Communication is key. And sometimes if they are not accommodated, persons with intellectual disabilities might experience barriers participating effectively and on an equal basis with others in court. So the decision also showed that there was actually a deficit within the justice system in Lesotho, and the deficit is to do with the provision of accommodations. And the failure by the court to deal with or to require the provision of accommodations, I feel, is also a missed opportunity. So in conclusion, I would like to say that the Kuadi Moshweshwe case was an important opportunity for the court in Lesotho to assert the rights that persons with intellectual and psychosocial disabilities are frequently denied. This, in particular, the right to legal capacity and the right to access to justice. And for the reasons I mentioned above, the court missed this golden opportunity. However, I will say just before I close that this does not take away from the fact that this is an important decision that removes the legal barrier that by which persons with intellectual and psychosocial disabilities were considered incompetent to testify in court. I hope I have not gone over my time. I thank you very much. That is the end of my presentation.
Thank you very much, Dianah. Sam?
Hi, everyone. It's nice to see you all this morning. I'm Sam Crane. Thank you, Dianah. That was a really interesting case study, and it's one that we're seeing quite a lot in the United States as well. So I'm the legal director of the Autistic Self-Advocacy Network, and we are the nation's leading self-advocacy organization, both by and for autistic people ourselves. And we have been following criminal issues for several years now. I'm going to present a few sort of case studies that we've been involved in. Okay, everyone can see my screen? Okay, great. So again, we're a self-advocacy network. That means that we're all autistic, including our board. And that includes people with significant communication and support needs. As Dianah's case illustrates, I want to really highlight that people with intellectual and developmental disabilities are far more likely to be victimized by others than to be perpetrators in a criminal context. People with intellectual and developmental disabilities are 3 times more likely than non-disabled people to be victimized by others. And people with cognitive disabilities are at the greatest risk. Most crimes are by people known to the victim, and includes abuse, including sexual abuse, bullying, and trafficking. People with intellectual and developmental disabilities, as Dianah pointed out, are at significant risk of discrimination in the criminal system, especially in the case of being found not to be competent witnesses, people believing that the matter is sort of a family matter, not getting accommodations in the courtroom. And this happens a lot. But we're also seeing a lot of people with intellectual and developmental disabilities experiencing discrimination as defendants in the criminal legal system. So there's barriers to adequate legal representation, what I'd call criminalization of autistic behaviors. Behavior that really shouldn't be criminalized is being treated as a crime. People are being caught in the school to prison pipeline, which is a system in which disproportionately Black children and children of color are pushed into the legal system as a result of their interaction with school. Unnecessary police interactions, which police are called to respond to a situation that really shouldn't be a police issue, and misinterpretation of autistic body language as lack of remorse or evidence of untruthfulness. We see that a lot. People on the autism spectrum often have special communication needs when they're interacting with the system, either as witnesses, victims, or defendants. And that includes a need for augmentative communication devices that help people speak, interpreters. A lot of people communicate best over text rather than speech. People might have sort of need for simple language or repetition, visual aids, redirection to keep people on topic. And sometimes people will need access to a supporter in order to communicate. And this happens, we'll see this happening in some of the cases that we're going to discuss. One sort of high profile case example, and we included our amicus brief in the readings for this panel, is Darius McCollum. He's a really interesting case. This is a man in New York who has a special interest in trains, transit. He's interested in the subway, trains, buses. He wanted to get a job as a subway driver, but he was rejected in part because of his history of hanging around New York subways, and occasionally drivers would let him drive the subway. This got him into trouble, and he was sort of banned from the subway. So he couldn't get a job as a driver. He was frustrated, and as a result, would impersonate transit drivers in order to be able to drive a bus or a train. He always followed the route. He never sort of drove off of the route. He never did anything particularly dangerous, but these were, criminal behaviors because he was because he was not authorized to drive the bus or the train. He didn't have any real access to services that could help him with this. And as a result, he had multiple offenses. He was incarcerated off and on for 18 years. A recent case in which he drove a bus without authorization led to a 2018 plea deal in which he was found not responsible by reason of mental defect, which is sort of offensive wording, but essentially they found that he was not guilty because his autism had led to the offense. But although this plea helped him avoid what was probably going to be a very lengthy incarceration, it's caused significant problems in the aftermath. When a person pleads guilty, not guilty by reason of mental defect, or what we often call NGRI, the typical result is that the person will be confined to a psychiatric facility indefinitely until they're certified as no longer dangerous or no longer disabled. So he is now confined to a psychiatric facility with no expertise in autism. He has limited access to, he has no access at this point because he's in the facility, but access to community-based services would probably be more effective at helping him avoid further problems. For example, if he had access to vocational rehabilitation, he could help find meaningful work during the day, and this would divert him from feeling the need to find meaning through driving buses or trains. We're particularly concerned by his placement in a facility because there is no medication for, unlike certain kinds of psychosocial disabilities, there's no medication for autism, and all of the interventions that are helpful for people like Darius are things that a psychiatric facility has really no expertise in. So the psychiatric model is likely to fail him because the facility is likely to continue to say he needs further confinement. They can't treat his autism. They're not going to get him to a point where he's where they believe that he can return to the community. He's likely to be confined in a facility for quite a long time. When we filed an amicus brief in this case challenging the judge's determination that he was dangerous and should be confined in a psychiatric facility. And one of the things we raised was that, first of all, the dangerousness determination typically refers to likelihood of violence. Darius has never engaged in violence. Second, we took the position that judges should always use the least restrictive option to reduce danger, and we set forth a new number of community-based options that would have helped Darius avoid further interactions with the criminal system. But unfortunately, we were unsuccessful, and Darius was committed to the psychiatric facility. They're now, as predicted, petitioning to keep him for another few years. So our lessons are that the existing frameworks often result in needless cross-incarceration through indefinite institutionalization. Judges lack knowledge about available and effective supports and services in the community. We really need more effective programs to divert people out of the criminal legal system. And racism in the service delivery system and criminal system can result in long cycles of criminalization. And we believe that racism was absolutely a factor in the system's criminalization response rather than offering him services at multiple points in this process. We also were involved in a case with Neli Latson. His full name is Reginald Latson, but he goes by Neli. And this is another case in which we see over-criminalization and unnecessary police responses really causing significant harm. The police were called to respond to an autistic teenager who was sitting outside the library before it opened. When confronted with by the police, Latson panicked and was later charged with assault on a police officer. He spent a lot of time in solitary confinement. There was significant use of restraints, which is abusive. And the community he ended up spending 10 years in prison as a result of this one interaction. The community really rallied around Neli's case because it sort of highlighted the issues around racism. For example, we know that he probably would never have been confronted by the police at all if he had not been a Black man. The over-criminalization at every step of his case. So a petition was sent to the governor of Virginia for conditional pardon. He won the conditional pardon in 2015, but as a part of that conditional pardon, he was required to be institutionalized in a Florida residential treatment center. As a result, 5 years later, he's still constrained by significant probation restrictions that were part of the conditional pardon. He can't move he has transferred to a group home, but he can't move out of the group home. He can't get a job or have a relationship without going through a probation officer. He has difficulty accessing home and community-based services because he moved to Florida in order to go to this Florida residential treatment center. His family moved to Florida to be with him, and so they're probably going to want to stay in Florida. But the home and community-based services aren't portable. He's still enrolled in Virginia Medicaid and living in Florida. So every time he needs to change settings or get access to different services, it's very difficult to get Virginia to agree to provide these services in Florida. So the lessons are we need to reduce police interactions. This case really should never have been a case for police to respond in the first place. At every step in the way, we saw racist and ableist bias among police, prosecutors, and courts. Addressing this bias would have prevented the confrontation, the prosecution, and probably the incarceration as well. Solitary confinement and restraints are abusive to all incarcerated people, but it includes and especially autistic incarcerated people. He experienced significant trauma as a result. And as with McCollum, we're seeing that diversion options may result in long-term institutionalization and lack of adequate access to adequate services. So we really need to look at our diversion options and make sure that they're community-based and community-focused and non-carceral to make sure that people aren't simply being incarcerated in a different context. We have seen a bunch of other cases, and I'll quickly go through them. Arnaldo Rios Soto, very high-profile case in which a man was sitting in the street with a toy truck. Someone called the police saying that he had a gun. It's unclear why they said that. About 20 police officers responded. One started shooting at him and instead hit his caregiver, who was pleading with the police to not shoot. Arnaldo, as a result of this trauma, lost his group home placement, was institutionalized for a few years. He was in a large residential treatment facility. He then went back to another group home. The group home that the second group home, as a result of a payment dispute, falsely called 911 saying that he was attacking people. This is contradicted by video evidence of him just wandering around the house being normal. He was picked up by the police, taken to the hospital, and kept at the hospital for a while before he was able to, I think they finally managed to get him home with some services. So Arnaldo was abused by the legal system at several points in his story. Caleb Moon Robinson, a 12-year-old child who was arrested after being confronted by school resource officers because he was in the school hallway without permission. He was arrested and briefly prosecuted in the juvenile justice system before community outrage caused the juvenile justice prosecutor to drop the case. And Matthew Rushin is another high-profile case that was very recent. He's an autistic man who was in a serious automobile collision. It caused very serious injuries to other people. He maintained that the collision was accidental, but due to communication challenges with his attorney, it appears that he pled guilty to a serious intentional offense, so an offense that requires malicious intent, which he now contends he did not understand that he was pleading guilty to intent. And as a result of that plea, he was sentenced to 50 years. 40 years are suspended, so he's likely to spend about 10 years in prison and 40 years in probation. And there is an outstanding pardon petition for Matthew Rushin. I should also say that in the Neli Latson case, there is currently an outstanding petition for a full pardon so that he would not be subjected to continued probation oversight after 5 years. So our overall lessons are that autistic people are at risk of victimization and police violence. Racism intersects with disability bias at all points in the criminal system. Reducing police interactions and increasing police accountability is critical to preventing unnecessary incarceration of autistic people. And we really need to be investing in diversion options that are community-based, time-limited, and integrated with existing home and community-based services programs. For more information, we do have several toolkits, including our safety toolkit, which addresses interactions with police both on the victim side and defense side. Our plain language resource on police, this is aimed at autistic people and families to learn more about autism and police interactions. We have a communication toolkit that could be very useful to people who want to know how to communicate with people interacting with the legal system. And the American Bar Association has some really good state court accessibility resources for interaction with the court system. Thank you so much.
Thank you very much, Sam. Colleen?
Great. Well, thank you so much for having me here today, everyone at Drexel, and then also thanks so much to the other two panelists. I think both wonderful topics that are very much set the stage to the things that I'll be describing today. So I am an assistant professor at the School of Criminal Justice at Rutgers in New Jersey. And as I mentioned, I'm a social scientist. And today I am going to talk about defendants with autism spectrum disorder in court, and specifically ways in which one may identify, both by offending behavior as well as courtroom behavior, individuals with ASD. I have kind of a long history of doing work in this area, empirical work. I've been very interested in studying how people within the court system particularly interact with and understand ASD. And specifically, judges have been the main population that I've worked with and have done several studies on. And so in general, the article that I'll be contributing to the symposium issue is going to be specifically related to judges, because again, that's my area that I have focused on related to ASD. I was really interested in kind of writing up a piece as a toolkit for members of the judiciary in trying to find ways to equip them with knowledge on understanding autism and how they can better identify, handle, and make different adjustments for diagnosed defendants. The first part of the article that I have written, which is now a much more polished version of the draft that I initially submitted, really focuses on ways to identify defendants with ASD in court, focusing on the distinctive characteristics that you may see as it relates to offending behavior of individuals, and then also the courtroom behavior. And today, since the population here and the audience, I think, likely are going to be more receptive to these issues rather than judiciary-specific issues, I thought that this conversation and this part of the article would be the thing that I would cover, because it can be extended to attorneys, which I know are probably the large majority of people who are watching here, and soon to be attorneys, and other court officials as well. So this won't just be a judge conversation, even though my piece is much more judicially oriented. This will be much more about how people in the courts can identify people with ASD by both offending and by courtroom behavior. So in general, existing case law and the existing research that I have done, as well as the little research that has been done by other individuals as well, has found that it's the presence of ASD and the symptomology that is associated with ASD is often unknown to individuals who work within the court system. Often the types of offending and courtroom behavior are contextualized by these factors, and in many cases the diagnosis is not known. Either it has been diagnosed previously and that diagnosis is just not known to the court, or clinically that diagnosis has never been made, and therefore the behavior may be exhibited in kind of ways that may not necessarily be considered typical, but are not necessarily something that may call a psychologist or some sort of other type of psychiatric hearing. And because of that, a lot of the time these symptoms are either chalked up to kind of odd or maladaptive behaviors, and there really isn't any kind of further inquiry into it, and it's overlooked during the process. And so because these behaviors can be sometimes unusual and sometimes maladaptive, they can definitely be misinterpreted. And there's been a lot of concerns within people in the court system, and then also people in academia and psychologists and other individuals who clinically work with these populations are afraid that this may bias outcomes and may skew dispositional outcomes, because such behaviors can be thought of as being potentially a lack of remorse, a lack of understanding of the situation, which could lead to prejudicial impressions of the individual. And so it's really important for everyone involved in the court system to be able to understand what you may be looking at, especially if a person hasn't been diagnosed or that diagnosis isn't known to the court. And it's really important to understand how the symptomatic presentation of ASD can interact with both this offending and courtroom behavior in order to avoid these misinterpretations. And this is, again, especially important for attorneys and people who work as advocates for these individuals, because often you're the people that are going to be interacting with these people the most. And because of that, can be an unfortunate kind of weight on one's shoulders to look out for these things, but it means that it's especially important for people who are very close and represent these individuals. And so one of the things I wanted to talk about today, because there's a wide range of symptoms that interact with both offending and courtroom behavior, is social impairments. There's a lot of different ones that I cover in the article and that are covered in the literature, but social impairments are probably the most prevalent, and I thought would be the best to focus on here since I have a limited amount of time. So we're going to talk about social impairments and what to look for, and talk about some case examples as it relates to offending characteristics and then impairments in the courtroom of individuals with ASD. So although evidence is mixed, and there has been a lot of limits in the methodologies that have been used for studying types of offending and individuals with autism, there have been some studies that showed that individuals, specifically those with higher functioning ASD, may demonstrate a higher likelihood to commit particular types of crimes. Could be arson crimes, stalking, different types of interpersonal violence, sexual offenses, and then computer crimes. But as I mentioned, these are extremely limited studies. The research is inconsistent and inconclusive. And so it really isn't, we're not really sure exactly how these types of offending map onto the symptomology of ASD. And so in general, what has been kind of discussed is that a better and more thorough understanding of this type of kind of offending nexus with ASD symptomology is looking at the characteristics of the offenses rather than the offenses themselves when it's perpetrated by individuals within this population. And so, and that's because individuals with ASD most often offend in some sort of association or some sort of overlap with the symptomatic presentation of their disorder. And so deficiencies in social interactions, as I've just mentioned, these social impairments, which sometimes has to do with difficulties with interacting socially, as well as responding to particular types of social cues, appear to be some of the most significant and enduring features of ASD and its relationship with offending behavior. And so characteristics of ASD, which include things that some of the other panelists have talked about, as well as in the introduction, things like social naivete, deficits in social emotion reciprocity, and other types of kind of normal responses to social situations often precipitate engagement in offending. And the psychologist Simon Baron-Cohen used the frame 0 degrees of empathy to characterize these types of social difficulties and deficiencies, because sometimes there's just a lack of empathetic kind of relationships in interacting that may be exhibited by defendants with ASD in offending behavior, which is obviously not something that they necessarily are attempting to try to show or interact with, but sometimes unfortunately is a symptomatic presentation of ASD. Individuals with ASD often also have difficulty in identifying emotional or mental states of others. This can include things like fear or distress of a person who ultimately might end up being a victim of some type of particular interpersonal offense. And they may not necessarily respond appropriately to that type of emotional or mental state. And that may contribute to the offense as well. And a good example of that was a man who had high functioning ASD who was convicted of the possession of child pornography after coming into contact with it while doing internet research to explore his sexual identity. And he didn't realize the kind of sensitivity of this type of material and how potentially there could be implications of looking at it. And by his own reflection, he even said, that he didn't fully understand the implications of such material. And I have a quote here that I'm going to read to you. So this is what he said. At the time, I didn't understand that downloading free images on my computer in the privacy of my residence could lead to the severe legal consequences I later experienced. I also didn't understand at the time that the children in the images had been victimized in the process of creating those images. I honestly had no idea that I was causing harm to anyone. It is very embarrassing to me to admit that I needed to have this information spelled out for me, as I wasn't able to make the connection on my own. After my arrest, Dr. Green spent considerable time explaining the issue of victim awareness to me. I was horrified to learn that these minors had been mistreated and that I had not been able to see that. Other social deficiencies associated with ASD, specifically naivete or the inability to recognize the intentions of others, can also lead to offending. And this can unfortunately lead to difficulties socially, outside of the courtroom, socially with individuals with ASD having difficulties making friendships, sometimes mistake malicious intentions or people taking advantage of them with friendship. And this can lead to a risk of exploitation, which can also overlap with offending behavior. There's one example of a case of a man who was arrested after stolen goods were found and kind of lined up in his front window. And it was later found that a neighborhood gang had, basically befriended him as a place to hide such materials so they would store them in exchange for allowing him to hang out with them. So they obviously exploited him into keeping these stolen goods because of the social interaction and him wanting friendship. As I mentioned before, insensitivity to social cues and then a lack of socio-emotional perspective taking can also render individuals with ASD having difficulty to understand kind of unspoken social rules and kind of unspoken kind of social interactions that or behaviors that maybe typically individuals may not show. This could be touching other people's possessions, standing too close, or not necessarily respecting personal space, not maybe looking into people's windows or looking at people's possessions in a way that normal privacy may not necessarily show. And further, social niceties, so smiling or saying hello, sometimes can be mistaken as signs of romantic interest, and that could lead to the potential pursuit of unwanted romantic relationships. There's a good example of a case where a man was charged with an assault after rubbing a stranger's body after she smiled at him as a social nicety, as an attempt to try to get to know her to see if there was a relationship that would come out of it. So those are some kind of quintessential impairments that might be seen when it comes to social interactions as it relates to offending. Let's talk a little bit about impairments in the courtroom. So as I mentioned, the courtroom behavior of ASD may be affected by the same types of symptomatic presentations, and without the knowledge of a person's ASD or without proper knowledge of the person's ASD and how it interacts with these types of behaviors, it could be misconstrued or viewed as prejudicial. And along with these social impairments, communication impairments, which often go hand in hand with social impairments, are the main symptomatic features that may affect courtroom behavior of individuals with ASD. So as individuals with ASD often have problems appreciating, again, perspective taking and subjective experiences with others, sometimes individuals defendants in the courtroom may not exhibit expressions of empathy in the way that an individual might who does not have ASD. This may mean that individuals may show inappropriate facial expressions at times that are inappropriate during, maybe when a victim is speaking or when a judge is speaking during a very particularly heavy part of talking, when someone is giving testimony or when evidence is being presented. A good example is in one case, a defendant with ASD was casually reading while his victim spoke and cried on the stand, and he smiled at her when she gave him eye contact, which was viewed by the court and by individuals as something that did not appear to be appropriate, and at the time his ASD was not known, and so it was viewed as being a kind of callous, remorseless behavior. Other similar cases have involved defendants laughing sometimes when individuals are speaking about their crimes in the courtroom, which can obviously be viewed as prejudicial. And it can make individuals appear cold and calculating and lacking remorse for any sort of type of behaviors that may be associated with their either past offending or with kind of some sort of empathy between themselves and victims in the court. Defendants also sometimes may say things that appear to be inappropriate or callous, such as laughing when talking about a victim during the court proceedings, or using sometimes very, emotionless language, or speaking about individuals without emotion, and using language that treats them as objects rather than individuals. And without knowledge of ASD, these expressions can sometimes make an individual look arrogant, dishonest, and make them look guilty and remorseless. Sometimes, in addition to having these type of non-emotional and it could be considered callous or viewed as callous interactions, sometimes defendants may show apathy or no interest in the proceedings, avoiding all eye contact with judges, attorneys, or other individuals. This sometimes has to do with the fact that individuals with ASD reduce eye contact when they're in stressful situations because of the amount of stimulation and the potential anxiety that may be provoked by such situations. And so that's something that's really important to remember, because such behavior, again, isn't necessarily indicative of remorselessness or some sort of kind of cold calculating views or someone not caring. It may just be a mechanism to reduce anxiety and stress. This is, again, can be especially hard in situations in which victims speak and when an individual cannot make eye contact with the victim, which can be misconstrued, particularly by judges during sentencing. And then finally, just a couple communication impairments that I wanted to cover before I concluded. So aside from social behavior, individuals with ASD may also exhibit odd verbal and speaking patterns in the way that in the manner and the tone in which one speaks. Sometimes phrasing is unusual. I talked a little bit before about the types of words that may be used. So phrasing may be unusual, nonsensical, and sometimes overly formal. They sometimes may take a long time answering questions, which can appear evasive if you don't understand that where the symptomology may overlap with these types of behaviors, and could also appear as rude because sometimes at the end of that, that may end with a shouting or a reaction or certain words to certain phrases, which could be, again, misconstrued if it is unknown how the symptomology overlaps with that. They also might misinterpret or nitpick questions asked of them during questioning or cross-examination about specific words or phrases, which again may show them to be kind of which may be perceived as being kind of not engaged with the material or not taking things seriously instead of answering the question, or evasive. Defendants also may fail to pick up on cues which signal the end of questioning, and may also attempt to shift conversations to a topic of their interest. So they may be in question about a particular thing and want to talk about something else and shift the conversation or answer a question that does not actually answer the question that was asked because they want to shift the conversation. And this could also be misunderstood as the defendant being evasive or unwilling to talk about a particular area of answers or questions. When questioned in one jury trial, a defendant with ASD instigated arguments with the prosecutor over comparatively trivial details while failing unless redirected to confront the underlying and critical question. And this also can be complicated sometimes by individuals not understanding literal language or non-literal language. So things like sarcasm, analogies, allegory, things like that. Those are often things that are misunderstood if they're used in interactions with defendants. And that can sometimes also lead to a miscommunication, which can create a whole host of problems, as I've mentioned. So as a conclusion, members of the court, and this includes judges, as I mentioned, but obviously attorneys, all this information is really important for attorneys, must be equipped with appropriate and awareness and resources on recognizing and understanding ASD to be able to identify defendants with ASD, as many of them, again, are not diagnosed or the diagnosis is not known to the court, and being able to make certain adjustments accordingly. And this doesn't, this not only allows for more appropriate accommodations legally, which my article talks a lot about, how this fits into things like fitness to stand trial, sentencing, elements of guilt, but a more holistic understanding of ASD's forensic relevance will ensure more just and fair consequences for defendants with ASD, since we know that individuals in the criminal justice system just don't have the knowledge or resources right now in order to make those appropriate adjustments.
Great, thank you so much. Thank you to all of our panelists. So one question that I have is, in light of the fact that there are definitely individuals who come into the criminal justice system who have not been diagnosed with ASD, either before the incident or even after that, can you talk to the need for experts and for defense attorneys, prosecutors to have access to experts, and courts to have access to experts, perhaps rather than expecting judges to make untrained lay diagnoses based on what they're seeing, but when they really don't have the clinical expertise to make a formal diagnosis?
So I did a study a few years ago on experts who have given testimony in criminal trials involving autism. It was a national sample of about 25 experts, and I was interested in the same kind of issues that you're describing. I had done a bunch of judge research, and I was interested in how experts could potentially provide the appropriate amount of expertise, since we know that experts are supposed to be educators of the court, and judges cannot be expected to be experts on anything, let alone experts on something that is so incredibly complex like autism. And one thing I found is that that experts really do take their jobs very seriously, view themselves as being kind of that first, stage of the whole process that they want to be there and be able to contextualize symptomology and how it interacts with the things that I talked about previously. They need to definitely be there to, you know, provide not only an appropriate diagnosis, but they also need to be able to contextualize previous offending behavior or previous history, any sort of previous clinical history. I think the main thing was being able to identify precise legal questions and be able to directly answer those with an understanding of how autism interacts with that specific legal question. So I talk a little bit in the article that I've written for this, and then in some of the other work that I've done, about how how there are, again, specific areas where autism is, you know, most important in kind of making procedural adjustments and considerations. This could be related to sentencing. It could be related to fitness to stand trial. There's kind of a variety of different areas where the symptomology is maybe most important. And experts really talked about being at these different kind of access points during the legal process in order to specifically speak to how sentencing an individual with ASD to a period of incarceration in a jail or prison may cause, you know, horrible consequences, or how that could potentially have negative kind of, you know, problems moving forward. And so the biggest recommendation I've given generally is that although judges and people in the criminal justice system, attorneys, and everyone who's involved in the kind of court process needs to have this background behavior, they can't do it on their own. And it's so important that if there's any sort of inkling that if there's the ability to provide expertise and get expertise, you need to be able to take those opportunities to do that. Because even if you go out and you know, make yourself the best expert that you possibly can be on autism as a court official, which is great, and I approve of that and I want that, you're never going to be able to have the same type of background, particularly clinically working with these populations, that these experts do. Most of these experts are individuals who are either psychologists or psychiatrists who have done training, fellowships, and had years of experience with individuals with autism. They've also been involved with a lot of cases involving autism, which means that they can draw from those and be able to provide those as well. So yeah, my biggest recommendation is to judges and then to attorneys and to everyone who's involved in the court system, if there's any inkling, do a little homework on for yourself, but attempt to try to get access to experts. And there are expert witness directories and other individuals that you can get access to pretty easily with the internet now to be able to find those. They're not as hard to find anymore. And so definitely use and tap into those resources if you can.
Great, thank you. Dianah or Sam, do you want to weigh in on this issue of either the availability of experts, the use of experts, or whether they are available, or whether there are resources to actually secure experts?
So I absolutely agree. There's a real, especially forensic experts who are qualified to evaluate ASD, there's a real shortage of those experts. But in addition, there are economic and racial disparities in access to experts that we really need to address. That, you know, for example, in the McCollum case, you know, these experts came, only even began weighing in on his case after he had been incarcerated off and on for 18 years, and he had gotten a lot of media attention, and I think an attorney started taking on the case sort of pro bono as a result of all of the attention that his case had attracted. So, you know, he would have been far better served if he had had access to experts 18 years ago, or, you know, 20 years ago. But even now, especially the people at the treatment facility really don't have expertise in autism in the first place. The other cases that I discussed, you know, Matthew Rushin, I reviewed the sort of sentencing transcript in that case, and it was clear that he probably could have benefited from an expert, but instead he had a sort of a very generic psych evaluation from, you know, someone who probably didn't have the level of expertise in autism as they could have. So we really need to increase the bench of experts that are available to people, but we also really need to look at reforms to fund those experts for people who otherwise wouldn't have access to them.
Great, thank you. Dianah, there are a couple of questions that have come through about the judgment that you were discussing, and so I'll ask them both together so that you can address them. But one was whether there have been any developments since that decision which do address particular accommodations or access to justice for individuals in the court system. And also, do you have any opinion about why the court didn't address the issues of legal capacity and accommodation, where you say it was a missed opportunity? Was there any strategic reason why the court might not have done that, or do you have any thoughts about that?
Thank you so much. So I think both are really good questions. The first one, so a trial de novo was ordered, but the case hasn't yet been tried. And there's a reason for that. And the reason is because they saw, one of the organizations that collaborated in bringing the case before the Constitutional Court saw that it's not really just a case of taking Kawadi to court and saying, there you go, take the stand and testify. But there's a need for providing accommodations in order for him to actually testify effectively in court. And so they also saw that there was actually like a gap there. There was no professional that they can turn to provide those accommodations in court. And so what they did was a series of trainings, which I was one of the people conducting them, this series of trainings on accommodations, and they were targeted specifically at criminal justice personnel. So the prosecutors, the magistrates, the interpreters, and a few defense counsels as well. So in terms of development since that case, I think there's been a lot more training going on around the issue of accommodations, a lot more awareness raising on the need for accommodations. Interestingly enough, last year, I did a training in conjunction with the International Commission of Jurists and the Lesotho organization, the umbrella organization for organizations of persons with disabilities in Lesotho. And we did a training for judiciary magistrates and judges. And the judges who were involved in this case were actually part of that training, including the acting Chief Justice of Lesotho. And we discussed this actual case in great detail. And so this leads me to the second question. So as we were discussing in great detail and these issues were coming up, the judges who were involved in that case, deciding that case, actually said, we did not know all of those things about legal capacity. You know, it's an issue of the government ratifies a treaty, but you know, there's very little awareness, you know, amongst people who actually have to implement, you know, what is the meaning of the treaties. So I know for a fact from that training that the reason why they didn't address these issues was that they were not aware of them at the time that they gave the judgment. They wrote the judgment. So I hope that answers the questions.
Thank you. And I appreciate you raising the issue of training as well, because that's, you know, certainly an issue. And I was struck as I was reading all of your materials about this question of whether when we're talking about being more sensitive to neurodiverse individuals, I also thought about these principles of universal design, right? Which means really making the world more accessible for everybody, right? Taking into account when you make the world more accessible for one group, you're really helping everybody, right? Making it more accessible. So to what extent, I guess, do you think training should be specific for the needs of individuals with neurodiversity, or broadening the training more generally? And I guess the broader question is the role of training versus the role of legal change, and maybe the role of legislation in enacting change versus relying so much on training and education, perhaps, of the judiciary. And so one of the quotes on the ASAN website that struck me with respect to police training specifically, there was a statement: ASAN believes that police should get training on how to deal with different situations without becoming violent, but ASAN does not support police training that is just about autism. Police need to treat everyone safely and respectfully. They shouldn't need to know we are autistic to do that. And so I guess, ask like how much should training be specific to neurodiverse individuals versus more universal, sort of thinking about these principles of universal design as applied to the justice system. And I think that ties in with our last question in the questions here, which was asking Sam Crane, do you think that due process should differ in any way for those with ASD?
I think that the principles of due process, it's important for the principles of due process to remain the same, but those principles won't necessarily be meaningfully achieved unless people have access to reasonable accommodations. And that can include communication assistance with their attorney, some sort of extra time with an attorney that other defendants don't necessarily require, assistance with presenting testimony. I know that there's this sort of ties into what Dianah was discussing, that an autistic person might require pretty significant accommodations to the testimony process in order to be able to meaningfully participate in it. So those are all going to be important elements of ensuring due process for autistic people.
Great, thank you very much. And so let me just thank our panelists, Sam and Sam's able helper, welcome, and Dianah and Colleen, thank you so much for being on this panel and starting us off with so many interesting things. This is a conversation that could continue and hopefully will continue for the rest of today and well into the future.